So we're talking today about starting a small business, specifically intellectual property concerns. So when we talk about intellectual property, what happens first? Well, you start off with an idea, and hopefully that idea can be conceived, produced, and marketed, and you can have fun doing it. So if I were in a meeting with you, what would we talk about? Well, we would talk about the basics of intellectual property, and those are trademarks, copyrights, patents, trade secrets, and the intersection of all of those together, plus cybersecurity and privacy. And we're going to be doing a separate session on cybersecurity and privacy in a few months. So, what is a trademark? Colloquially speaking, a trademark is a source identifier. So it's the name by which you are known to the trade and the public. It can also be a slogan or a logo, which is a design. And what is the goal with regard to a trademark? What do you want that trademark to say to the trade and to the people who may be buying your products or services? So in choosing a brand, you have to think about first, what will your consumer think about your business? How will your brand link in to your promotion and marketing campaign? How will your brand become a reservoir of your goodwill? How will the trade look at your brand? And what does your brand say about your business reputation? Another concern is to avoid tarnishment. So when choosing a brand, we want to make sure that it's not associated with something that is pre-existing, so that when your brand is being researched, let's say someone is putting in a search request on a browser, you don't come up as fourth, fifth, or sixth after something truly unpleasant. So we want, when we search a brand, to make sure that it resonates with you and your mission and what you want to provide. But we also want to make sure that it's not associated with anything that is really nasty. We also want to avoid consumer confusion. So the first step is to create this new name, slogan, or logo. And we'll talk about that in detail. So what kind of names are the best to choose? Well, unfortunately, those are the hardest to find. The best names are those which are fanciful. And when I say best, I'm talking about a trademark hierarchy, where we are going from fanciful to arbitrary to suggestive to descriptive. So if we look at this chart, we see Google. Google is a fanciful name. It doesn't have any meaning in any known language. And you might think, well, Amy, we're here in the United States. Yes, the primary form of communication is English, but in the trademark office, that's not what's important. If you wanted to run a window company and you chose Ventana as your name, well, that means window in Spanish. So the trademark office would simply translate your foreign word into its meaning. And then they would reject you because you're descriptive. So best in trademark parlance means fanciful, a name that has no meaning in any known language. And most clients come to me and they don't come with fanciful names because those are really, really hard to think of. Now, from a search perspective, it's usually much easier to clear a fanciful name. But then with regard to your marketing strategy, you have to think about, well, how do I teach the consumers and teach the trade what I do if I don't have anything in the brand that suggests what I do? So it's a bit of a conundrum. But Google is obviously a very well-known brand name because they put the marketing and advertising behind it. Now, what comes after fanciful marks? Arbitrary marks. Ivory is an arbitrary mark. Ivory was established over 100 years ago for soap. And ivory can be the quality of the soap, the color of the soap. So ivory is sort of straddling that barrier between a truly arbitrary mark and a suggestive mark. Now, Nike is a truly arbitrary mark. You may be thinking, wait a minute, Nike has a real meaning? Yes, it does. Nike is the name of a Roman goddess. So it's arbitrary because the mark has a meaning, but Nike as a Roman goddess doesn't mean anything with respect to the products that Nike sells, the apparel and the shoes and other products. Now, if we look at the swoosh that is below Nike, that's a logo, and that is truly fanciful. That's something that Nike created and everyone recognizes because of the marketing and promotion that Nike did. Now, on the bottom right side is Hearts, a very well-known brand name for pet products, also established very, very long ago. Now, Hearts is a surname. It was the surname of the fellow who established the company. And you know what he first sold? He sold canaries. So surnames can be registrable, but not if somebody has already registered the surname. So if your last name is McDonald, I'm sorry, but you can't open up a restaurant of any sort because McDonald's, well, they've already wrapped up that market. Now in the middle is thermos, and it has this little R symbol, but that doesn't have any relevance anymore because thermos is generic. Everyone started calling the thermos a thermos. So now that is the word that we use to define the product. So while a thermos was registered many years ago, it is no longer on the register, and anyone can use the word thermos because it is generic, it is the name of the thing. And now let's talk a little bit about some descriptors. I mentioned that before when we went through the Ventana explanation. There are words that can be registered where they are a combination of a descriptive term and an arbitrary or a fanciful term. There's a window company called Windowrama. So by use of window, they're telling people, well, we do something with windows, but the Rama portion doesn't have any meaning directly in connection with windows. So to recap, when you're choosing a mark, do your best to be fanciful. And you may say, well, that's really tough. And I will say, well, you can look at foreign languages, you can look at names of plants, you can look at unusual names, and you can start mixing them up to develop a brand that may resonate with you, the trade, and your potential customers. So what's the process after you've come up with a name? I never recommend that you come up with just one name because it's highly likely I'm going to tell you it's not available. So it's best to come up with several names. And that way you're not terribly emotionally attached to a name that we cannot clear for you. So how do we clear the name? We'll first do a preliminary or knockout search, looking at the Federal Register in the United States Patent and Trademark Office, where all applications and registered marks can be found. So we will do that search and we'll tell you yes or no. We will also look online, again, for that reputation issue that I mentioned before. We want to make sure that nobody is using that same mark in common law. So we run two systems in this country. One is, yay, I have a registration. It gives me nationwide protection as soon as I file it. The other is, I'm using the mark in common law. So I'm all over the internet. Do I have nationwide protection? The answer is maybe. It's always best to have the registration. So we'll do a search online too, just to make sure that that brand is truly available, because someone with prior rights and no registration can challenge you. And then if we are perfectly happy with that search and you are perfectly happy with that mark, we may recommend a full comprehensive search, which basically searches everything, everywhere across the United States. And we get this 300-page volume that we have to review. Now, the pro of federal registration is that nationwide protection. You could go into court and say, I've got a federal registration and it's good as of this date. If you have common law rights, well, then you have to prove secondary meaning in each and every jurisdiction. And that's a lot harder. You have to prove that people recognize who you are and that you have exclusive rights in the mark. The federal registration gives you that automatically. So what's the process? Well, let's say you have been using a mark in commerce, and let's say we don't find any problems. We will file based on use in commerce. The process takes about a year. The trademark office takes about 8 months to evaluate the application, and then 30 days. What's 30 days, you ask? Well, the application is published for third parties to oppose. So if someone says they've got prior rights or they think your mark is descriptive, they can oppose the application. If no one opposes, about 2 months after the end of that 30-day period, you will get a registration. So that's the use track. But what happens if you've just developed your brand and it's going to take you a couple of months to launch? Well, have no fear. We can file based on an intent to use, and you can preserve your right to that mark against any later users or later filers by filing an intent to use application. So, and that's a really good way of just knowing that your mark has been cleared and that you've filed. Now, continued use and renewal. Once you get your registration, 5 to 6 years after it, you have to renew it. And in the United States, renewal, well, it's based on use. So is your intent to use filing. So you file your intent to use application, it's blessed by the trademark office. You have to file proof of use in order for the registration to be granted. And then you follow up with proof of use in the 5th and 6th year after the registration was granted, and every 10th year thereafter. So there are marks that have been on the register for 100 years because the companies are that old and they've been using the mark continuously and filing the appropriate documents. And after that 5 to 6 year filing, your mark is incontestable, which means there are certain grounds upon which that mark cannot be challenged. Now, you see here enforcement necessary to preserve the value of the mark. This is something that's peculiar to the trademark law. If you don't enforce, in other words, go after infringers of your mark, you're steadily eroding the rights that you have in that mark because you're letting everyone else use it. And you therefore are diminishing any exclusivity that you might have had. So when you're choosing a mark, you want to make sure that it's something that you can put in your Google alerts so that you can see if somebody else is using it and take the appropriate enforcement action. There are also watch services that we subscribe to, and we get a daily report. So we can advise you if someone else is using your mark, and we can take the appropriate action. Now, we've been talking about the United States. That's because trademarks are territorial. If you apply and use your mark in the United States, you have rights only in the United States. So if you're going to be manufacturing a product outside the country, it's always best to file in that country as well and search in that country. So in an initial conversation, we're going to get a lot of details. What is the product? Where do you intend to manufacture it? Where do you intend to sell it? And if we file outside of the United States within 6 months of the US filing date, then the foreign application will be treated as if it was filed on the US date. So let's say you decided to file an application on April 1st in the US and you're manufacturing in Mexico. If we file in Mexico on September 1st, you're within that 6 months, and any application that was filed in Mexico between April 1st and September 1st for a similar mark for similar goods or services, well, it will be denied based on your earlier filing. Now, we haven't gone into it, but we're going to discuss it now. How are you going to use your mark? on what goods and services. The registration system is based on classifications. So apparel and footwear and headgear are in class 25. A software platform may be in class 9 if you're providing downloadable, or in class 42 if it's not downloadable. So each class costs money. So we can file a multi-class application to reduce those fees for you. The filing fees stay the same, but the legal fees are less because we're doing it all in one application. And most foreign countries follow the same classification system with a little bit of variation as to word usage. So when we search, we're going back to the search, if you're going to be manufacturing outside the country or providing services outside the country, we're also going to search for availability in the other nations. And again, registrations are territorial. So you'll need to register in order to protect your brand everywhere that you might use it. Now, many other countries don't have a use requirement, so you can get a registration without providing proof of use, but a third party can challenge your registration within a certain number of years if you don't actively use the mark in that country. So to sum up, you want to choose a brand that resonates with you and resonates with your customers and with the trade. You want to make it unusual and unique, not only for ease of search and registration, but because that way you're really building up an exclusivity in that brand name, and you're enabling effective, efficient search engine optimization when people put that name in a browser. The more common the name, the less effective search engine optimization will be, because you'll get a lot of hits unless you're going to pay a lot of money for AdWords. Now, shifting gears, let's talk about copyrights. So a copyright is an original work of authorship fixed in a tangible medium. So this includes artwork, photographs, videos, sound recordings, music, a website, including what you see on the website, software. So it's basically what you produce after you've had this great idea. It has to be fixed. Now, even though the right attaches once you create the work, we don't typically file until the work is published, launched. So you can create the work. Let's say you're creating a quilt that's really beautiful and ornamental. We will file once you've offered that quilt for sale. And then the other aspect of copyright is that it has to have sufficient originality, which means that a set of a quilt that's just a red line intersecting a blue line intersecting a red line in a very standard pattern won't be sufficiently original. But a quilt that has the red line intersecting the blue line in a very non-standard pattern with other lines intersecting and bubbles and hearts, well, that will be considered sufficiently original and capable of being registered. In the Copyright Office, we've got this 3-month window from that first date, that first launch date. And that enables you in a later litigation to ask for monetary damages and attorney's fees. So if you don't file with that within that 3-month window, well, that request goes by the wayside. Now, why are monetary damages and attorney's fees important? If you win your copyright case and you filed within the window, you will get your attorney's fees back. And that's very unusual in US law. Almost never happens. Now, with regard to the trademark, the situation is a little bit different. Doesn't matter when you file, but it matters that you use the R in the circle. If you use that R in the circle, then you have the right to ask for monetary damages and attorney's fees. So I mentioned platforms, software platforms before. So service as a software, platform as a software, they're all registrable. You can register the code, you can keep the trade secrets secret, you can register what it looks like when you go on the website. And it's really powerful because copyrights last for a very long time, because Disney, every time Mickey and Minnie has come up, has extended out the length of the copyright, the term of the copyright. So we're now between 95 and 120 years, really long time, and it's very cost efficient. So when you are, let's say, hiring someone to do the work, because you're not a software developer, it's critical that you get an assignment of all intellectual property rights so that you own the software and you own the screens, everything that is online. Because if you don't have that written document, well, I have news for you. The software developer owns it, no matter how much money you've paid to them. You don't. So that intellectual property assignment is critical. It's also really important with regard to hiring any vendor that is doing work and giving you deliverables or a work product that may have intellectual property rights inherent therein. So you want to have that contract. And with regard to offering a software platform, what's really important with regard to the consumers who are buying that platform is that your contract details be very clear. You want your consumer to opt in and know exactly what it is that they're buying. You want to make sure that you've got the proper insurance. So the devil is in the details here. Now, let's go to patents. Patents do not give you the right to make your invention. I repeat, the patent doesn't give you the right to make your invention. The patent gives you the right to exclude others from making, using, selling, or importing an article, method, composition, or design. So you could be issued a patent and still receive a cease and desist letter from somebody else who has a patent who is saying, well, my patent covers your product. So it gets very, very technical. Now, mechanical devices, a chemical composition, like a pharmaceutical drug, certain processes, let's say it's the process of making a drug, and designs can be patented. But anything that is considered an abstract idea or law of nature cannot. So a mathematical equation, for instance, cannot be patented. Now, let's look at some patents. So this is a hood with certain clasps, and it actually rolls up into a small pouch. This is the subject of a design patent. Now, we could not have filed a copyright on this hood because if we look at the image, well, it's a red hood with a logo on it. This is not sufficiently original under the Copyright Act. If the hood had a design on it, a pattern on it, then that pattern could be registered, but it wouldn't cover the functional features of the design. That is for design patents. And you've got to file the design patent quickly because even though the US has a grace period for filing patent applications, many other countries don't. So once you have your design, and it's the final design because we can't make any changes to the drawings, we will file a design patent for you. Now, this is an outdoor game, which is a lot of fun, called Ramp Shot. Now, here, this is a mechanical embodiment of an angled board and methods of playing the board, and that's covered by a utility patent. Now, what can we do with utility patents? Once you have your idea and you're pretty much set, but you're still figuring out minor details, we can file what's called a provisional application. And if you see here, that's what we did. We filed here a provisional application. And that is a worldwide placeholder. So you've got a year after you file your provisional to really figure out all of the nitty-gritty details of your patent. And as long as we file the next stage within that year, you get to rely on that earlier filing date. And that earlier filing date is good as against anyone who might file an application on on a similar mechanical device or process after you. We used to run a system of first invent, but we changed that a while ago to conform to what the rest of the world does. As I said, the provisional application is a worldwide placeholder. So what happens at the end of that year? That's a decision point. You can decide, okay, I'm just going to go forward in the US, or I'm going to have a formal placeholder, and I'm going to file that via the Patent Cooperation Treaty. Now, there are many, many countries that belong to the PCT, but not every country belongs to the PCT. So we go through that with you to determine where you file. And then within a certain period of time, you're going to decide, okay, I'm going to go forward and have the US look at my application. I'm going to have China look at my application. I'm going to have Europe look at my application. And each of those individual patent offices will tell you yes or no. And the process takes several years and is expensive. But if you have an invention that you truly believe in and is patentable, this is something that you may consider. It's also important to consider intellectual property in the context of growing your business, because the more intellectual property helps your business grow, the more you may be able to get outside investment because you have value in that business. You are developing that value in your business. Now, we haven't discussed trade secrets. So how are trade secrets different from patents? Well, when you have a patent, it's obvious after you've built the product, it's easily reverse engineered. Anyone looking at the patent is supposed to be able to duplicate it. That's the whole purpose of a patent. It's a limited exclusionary right for 20 years in the case of utility patents and 15 in the case of design patents. And after the patent expires, anyone can copy. A trade secret is different. A trade secret is really valuable. One of the most famous trade secrets in the world is the formula to Coke. Even though if you look at a Coke can, you know the ingredients, that doesn't mean you can duplicate Coke because the formula, the recipe, is not disclosed and is not kept online. That's literally in a lockbox. And only the people who need to know the formula have access to it. Trade secrets can last forever if you keep it secret. So that's really, really important. If you've developed a recipe where it's not easily reverse engineered, let's say, it's another drink, then keep it secret and only disclose it to the people who have a need to know. And if those people are not your employees, or even if they are your employees, you want to make sure that contractually they are saying, I recognize this as a trade secret and I'm not going to disclose it outside of this special circle of friends. And mark it as a trade secret. It's really difficult to go into court and say, Your Honor, so-and-so stole my trade secret if it's not marked that way. Now, we're going to discuss this a little bit in preparation for number 4, but when you go onto a website, you see privacy policies and terms and conditions of use, and most people ignore them. But it's actually really important to take a quick look at them because you want to know if you're giving out your email address or a phone number or credit card information. You want to know what the company is doing with that information. It's also important from a customer service perspective. If you're selling your product online and you're going to be constantly communicating with that customer, you want the customer to know that by providing their email, they're giving you permission to communicate with you. Either you're offering contests or sweepstakes or discounts, whatever it is. Look at these policies as part of your marketing and communications effort and your effort at being transparent with your customers and with the trade. Again, cybersecurity, that's going to be the subject of another lecture or speech, however you want to term this. But it's really important that you do disclose your data collection processes and that you do have data security. But we're going to get into that in number 4. So, Maggie, are there any questions that I may answer for the people who are in attendance?
Yes, Amy, we have some questions. Thank you so much for presenting. I'll remind everyone, if you have a question, you can use the chat box or email info@savvyladies.org. And we had some questions about financial aspects of trademarks, patents, copyrights, specifically how much is the intent to use and how much does a trademark cost? So is there a ballpark number or something that you can just kind of let us all know about financial aspects of this?
Yes, so it really depends on whether you're going to go and do this on your own, which is possible, or use an attorney. So the fee schedule is available at uspto.gov, and those are the filing fees. Attorney's fees also depend on exactly what you're going to be doing. We have this conversation with our clients, and it depends on whether you're going to be filing, let's say, just in one classification. That'll be one legal fee. If you file in 2 classifications, then we'll add on for the second classification. So it's a discussion that we have in private with our clients. Now, let's say you want to register in the US and outside of the US. You're certainly looking at several $1,000s there, simply because the filing fees outside the US are typically a lot more than the US filing fees, which tend to be a few $100s per class. I want to emphasize that. And if you file an intent to use and file the proof of use within 18 months, there's another filing fee for the proof of use. But let's say your plans got mislaid for some reason. The trademark office will allow you to file 5 extensions of 6 months each. Of course, there's a fee associated with that as well. And we provide a free consultation so that you can get an understanding of the fees doing it on your own or the fees using an attorney. The copyright fees are available on copyright.gov, and the patent fees, again, uspto.gov. Of all of these, I obviously recommend that you use an attorney, but with regard to patents, we have to take an open book exam that has a 1/3 pass rate in order to become a patent agent. So that gets to be a little bit more difficult to do it on your own.
Okay, thanks, Amy. Thanks for all of that information.
You're welcome.
Helpful. We have another question that is asking, in the fashion industry, do you recommend that the IP is owned in a separate legal entity outside of the operating company?
Well, I can't really give a blanket recommendation, and that's actually a pretty common question that we receive. The operating company is the one that is presumably using the mark on the goods. So if you set up a separate entity, there has to be an agreement between those 2 entities as to the use of the mark and control between the owner and the user. And then you're getting into royalty payments and tax implications and whether there's common control among the entities. So it gets really, really complicated. There are some reasons to do it and there are reasons not to do it. And they tend to be very individual with regard to particular situations. So it's not a question I can really answer without understanding that particular situation and speaking with your accountant. All of your business advisors are part of this decision-making process. Now, in the fashion industry, I discussed copyrights and design patents. So Jimmy Choo, for instance, has many, many design patents on his shoes because they're not original enough for copyright protection. The same thing with handbags. The handbag hardware, if they are novel, could be the subject of a patent application. The design, the appearance of the handbag, the subject of a design patent application, not a copyright, typically because there's no ornamentation sufficient for that pattern.
Okay, thank you, Amy.
You're welcome.
Another question says, I just registered our logo. Now that we uploaded them to the copyright.gov, can we now begin to use them on t-shirts, or is there a time period that we need to wait?
Okay, so if you've filed a copyright application and you haven't received the registration yet, is that the question?
It says just registered our logo and uploaded them to copyright.gov.
Okay, so registering the logo indicates to me a trademark registration, not a copyright application. Logos cannot be registered with the Copyright Office if the purpose of the logo is a source indicator, if the logo is your brand. I mean, if we're looking at the slide that says data security, let's say that you were a data security company and this was your logo. This is not copyrightable here. Your logo is registrable in the trademark office as your source indicator. Now, you could put this on a garment quite easily, but I don't know if the Copyright Office would register it. They might not consider it to be original enough. So we're talking about two different things. You can always use your logo on a garment. There's nothing preventing you from doing so, but the Copyright Office may not register it because it's not original enough. When you see logos on shirts, that's for the trademark purpose, although sometimes the trademark office won't accept that as a specimen, but that's another story entirely.
Okay, thank you. Looks like we have two more questions for you, and this next one says, if I have something trademarked and I see someone else is using it, what can I do about that, or what should I do about that?
So as we discussed, you have an obligation to enforce. So what we would do is investigate this other use. We would see whether this other use of the trademark came before you, in which case they may have rights that predate yours, or came after you, and if the other use is for the same goods or services. So you can have the same trademark being applied to windows and apparel, and that wouldn't be considered confusingly similar. That's the standard. Is this other use going to confuse your customers and the trade such that they think these other people are authorized, sponsored, endorsed, licensed by you? And you should always find out whether you should be enforcing it, because if you don't enforce, remember, you whittle down your trademark rights.
Okay, thank you for that. And this looks like the last question, and it's asking, if you get a cease and desist letter, do you need to hire a lawyer, or does that mean you just stop using what they're saying you need to stop using?
It depends on the circumstances. Certainly, I can't answer it in the abstract. In my view, as an attorney, it's always good to get advice initially, because then you don't get yourself into trouble that will cost a lot more, in an extrication process. Sometimes you can call up the other side and say, I'm going to stop. That'll be the end of it. Other times it's not so easy. So it's really situational.
Okay. Thank you for that. All right, those look like the questions that we have for you today, Amy. So if anyone has further questions, is there contact information
Sure.
you can share?
So yes, it's on the slide.
Okay, great.
Right
Thank
there.
you.
Mm-hmm.
And we will make sure that we send this out over email, so you'll have that directly. And we will also be following up over email with a link for Amy's upcoming webinar, as she mentioned, part 4, cybersecurity. That's in the next few weeks, so we hope everyone joins us again for that one. Thank you so much for presenting today, Amy. It's a lot of information, and it's really very helpful for everyone who's starting their businesses or continuing to grow their business.
Thank you so much, and thank you for your time today. I really appreciate you spending that time with me, and please feel free to contact me with any questions that you may have. And please look at my LinkedIn and our Savvy Ladies LinkedIn and Facebook, and promote the women that inspire you.
Yes, we will make sure we send that over email as well. Thank you so much, Amy, and thanks to everyone for joining us today. We'll follow up over email, and thanks again.
Take care. Have a great day. Bye-bye.
Bye-bye.